Good afternoon, everyone, and welcome to the webinar, Proactive Prosecution, Protecting the Record and Overcoming Pretrial Issues During COVID-19. Today's program is presented by Equitas. My name is Cynthia Hatchell. I'm the project coordinator at Equitas, and I will be moderating today's webinar. If you have a question during the presentation, please enter it in the chat box to your right. We will answer questions at the end of the webinar. You're also welcome to contact us directly at any time following today's presentation, and we will send you contact information during our follow-up. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As a national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website at equitasresource.org. You can also follow Equitas on Twitter, Facebook, Instagram, and LinkedIn. The link to each is available on our website. Today's webinar is supported by the U.S. Department of Justice Office of Violence Against Women. The information presented in this webinar does not necessarily reflect the views of the Office of Violence Against Women. Presenting our webinar today are Equitas attorney advisors Jonathan Curlin and Patricia Powers. Currently an attorney advisor with Equitas, John Curlin worked for 16 years as a prosecutor in the District Attorney's Office in Berks County, Pennsylvania, serving as Chief Deputy District Attorney, Chief of Trials, and Assistant District Attorney. Throughout his career, John has successfully prosecuted a variety of offenses, including domestic violence homicides, campus sexual assaults, cold case sexual assaults, intimate partner violence, stalking, child pornography and exploitation, child abuse and molestation, and human trafficking. Patty Powers joined Equitas as an attorney advisor after serving as a senior deputy prosecuting attorney in Washington State for 27 years. During her tenure as a prosecutor, Patty supervised the sexual assault domestic violence unit in her office. She frequently and successfully prosecuted sexual assault, domestic violence, child abuse, and related homicides, which included complex litigation of high-profile and cold cases. For 5 years, Patty served as a highly qualified expert for the United States Army Central Intelligence Command, through which she consulted and provided specialized training on military sexual assault and domestic violence. I will now turn it over to Jonathan Curlin and Patty Powers. You're muted.
Well, we're already off to a great technical start. Thank you so much for the introduction, Cynthia, and good morning or good afternoon to everyone attending today, depending on your time zone. Thank you for participating, or if you're viewing this as a recording from our archive, thank you for checking it out. We're here. This is a third in a series of webinars we've done throughout the COVID pandemic crisis. Part one was talking about trauma-informed responses in interviewing techniques and practices in the context of COVID. Part two was about jury issues and jury practices in the context of the pandemic. Those are both available on our archive. But today we want to start talking about some of the pretrial issues that can crop up and anticipate or just figure out ways to adopt approaches in which the issues, both anticipated and maybe unanticipated, can be mitigated and responded to as prosecutors. So broadly speaking, the objectives we want to accomplish in this webinar is try to proactively identify legal issues arising from pandemic-related delays. And in the development of this piece, Patty and I have tried to bring up some of the obvious issues that are probably going to be developed based on our own experiences and some questions we've been getting from the field. and talk not so much about bright line solutions, but approaches to these problems. Hopefully, some of the practices and methods that we're going to suggest in this webinar are going to be helpful and useful even for those issues that haven't been identified yet or that are going to be truly novel. Because of course, what we're also going to be addressing is that the motions raised in the context of COVID-19 and the pandemic, they're going to be unique to the accommodations and adaptations we've all had to develop as a society and certainly as criminal justice professionals. And we're also going to talk about something that's a practice that's useful both pre and post-pandemic world, and that is making effort to develop detailed and thorough records so that we can hopefully have an appeal-proof record or an appeal resistance record. And we can always point out to our appellate clerks or appellate courts, the judges and their clerks, the due diligence that we've undertaken as prosecutors so we can mitigate any defense issues or defense challenges raised on appeal. So, and that's really the first approach we're going to be taking. And while we're going to be really addressing these in the context of COVID-19 pandemic restrictions and practice adaptations, really a lot of the practices and suggestions we're making, they're good practice in any circumstance. And that is, as prosecutors, trying to think of a way to make appeal resilient records. And hopefully these are practices that are going to be useful no matter the nature of your office. Whether you're coming from an office where maybe there's a demarcation between the folks handling appeals and the folks in trial courtroom, or if maybe you're in a smaller office where you have truly a vertical prosecution from the time a case is charged up and through any appeal or post-trial appeal in your courts of last resort in your jurisdiction. Initially, we want to frame this or start talking about, especially in relation to pandemic backlogs, how to triage our cases for trial. And in this context, what we're really worried about and what we're really trying to address is, of course, even though many of our jurisdictions have issued emergency orders suspending speedy trial rules, now in the previous months, those rules might have been lifted, and so a backlog might have developed, and our speedy trial challenges may be starting to accrue or build up over our universe of cases. We want to talk about some general principles about how to triage these cases and make a record of how we're prioritizing these cases for trial in order to meet and consider our speedy trial issues. So one of the things, obviously, just like prior to the pandemic and before 2020 changed our world, we want to be thinking about speedy trial issues based on any prior or current delay. So one of the issues or factors for triage is how long do we have in this case before speedy trial rules or delays or limitations are going to be implicated. The other thing we want to be figuring out with our cases too is we want to be thinking about the impact of a delay on a victim. We really want to be thinking of this in a couple of facets. One, we want to recognize, like, gee, is this delay on our victim, could it maybe leave them unavailable or unable to participate if the trial is delayed any further? But we also want to think about it from a victim-centered perspective. That is, gee, by delaying this case, are we maybe compounding the trauma on our victim as opposed to a quicker resolution? Maybe for some victims, a delay or having the case handled later is going to give them a better window to process it and might not be as advantageous to that victim. But we want to make an individual assessment in each case. The other thing for triaging for trial, in addition to just the time that's elapsed or the time we have left in a case, we also have to consider it within the context of the availability of witnesses and respond or list these cases in the context of the availability of our potential witnesses. When we're doing this too, and when we're deciding which cases we are taking to trial, and just as importantly, which cases we aren't able to take of a trial, either because of limited court time or limited calendars, we want to be putting on the record how we're prioritizing these cases, not only for the cases we are choosing to go forward, but also just as importantly for the cases that we aren't able to bring forward immediately. And the reason why we want to be doing this is putting on the record, stating to the court either in a written motion or orally in front of the judge, so that there is some sort of record of our diligence, that we're just not willy-nilly deciding not to bring a case forward, but it's made within a holistic kind of context. So the speedy trial issue is probably one of the most immediate challenges that's coming up with the issues that are raised by COVID-19 lockdowns and shutdowns and the limitations caused by that. So we talked about that issue first, but it's really bringing us to really what's going to be one of the central focuses of this webinar is Patty and I, we cannot anticipate every issue the creative defense counsel that's going to raise or that's going to crop up maybe in our individual cases. But the one thing we can do to suggest to hopefully mitigate these issues and respond to the issues is that in this day and age, just as in every day and age as criminal prosecutors, we want to maintain a diligent and hyper focus on developing this record. COVID-19, of course, is pandemic. COVID-19 pandemic, it's novel. We don't have a roadmap to it. And the impacts to this criminal justice system are going to be outside the norm, and some of these ripple effects and consequences we can't predict. But what we want to make sure that we can do as prosecutors is we want to routinely provide detail on the impact of this pandemic on the criminal justice system and the efforts we're making to accommodate. And the reason why, if we're making this detailed record, it's going to help protect the case on appeal. And by providing this kind of detail, maybe what we want to be doing on our case is we even have a sort of rote boilerplate statement ready on the scope of the impact, both in of the pandemic, both its impact in our community in terms of shutdowns or hospitalizations or infection rate, as well as maybe the delay it's had or impact it's had on our ability to process cases, to bring cases to court, and make that sort of language part of the record in every case we bring. So then we have that record ready, even for those cases where we're not seeing the challenges that are going to be cropping up later. Because one of the inevitable truths of litigation is that appeals are going to be inevitable. They are always going to be happening. Defense attorneys are always going to be looking to preserve the rights of their clients. But however, with careful preparation, reversals don't have to be part of that appeal. So what we're suggesting not so much is looking to prevent the appellate process, but more importantly, looking for practices and methods that we can prevent reversals or remands, because those often are preventable, especially if we have an expansive enough record. So what's the sort of error that's preventable? And how this fleshes out in each individual case is going to depend on the circumstances or issues raised. But a lot of common causes of reversible record in appellate litigation is going to be something involving maybe a failure to lay a proper foundation for evidence, maybe a failure of trial court to place reasons for rulings on the record, inadvertent introduction of improper prejudicial testimony, or erroneous jury charges or instructions. Maybe some of the times these errors crop up because as prosecutors, we didn't know what we didn't know. Sometimes the reality is sometimes maybe these errors crop up because you have a trial court that might be really impatient to move things along and doesn't maybe want to give us all the time to develop the record that we would have preferred. But these are issues that we should always be conscious of and looking to develop and have as thorough a record and complete a record as possible. And for discussion about what we mean when we talk about a complete record, I'm going to hand things over to my very impressive colleague, Patty Powers.
Thank you so much, John. I'm really excited to have this opportunity to be working with John today, and want to thank all of you for participating and those who might view this webinar in the future. Our focus, as John has very eloquently described, is on proactive prosecution. We want to foresee, to the extent possible, any potential claims of error or arguments that the defense might be presenting. And so looking at the record, first of all, as prosecutors and trial attorneys, this is almost a word of art for us, making the record, protecting the record. And we all know that original papers and exhibits are certainly part of the record. Transcripts of any ancillary proceedings, if there are any, this also is part of the record, as well as docket entries, recordings or videos that are played in court. are also part of the record. What also is important to consider, in addition to these aspects of the record, are our observations as trial counsel. This is a very important part of our work as prosecutors in the pandemic, regardless of whether we're involved in virtual proceedings or socially distanced proceedings, maybe with masks and plexiglass in our own courtrooms, or maybe even in alternative facilities. We can foresee that there are going to be claims advanced by the defense. For example, the defendant is unable to assess through counsel the demeanor of witnesses, just to use one small example. So our observations, what we are seeing, what we are able to see, what we are able to hear, can be very important. So we're suggesting that adding to the record, observations is also a critical part of our work. Now, any of us who have responded to or brought challenges for cause know that our argument will be supplemented by observations that we may have of the panelists. A panelist, for example, shaking his or her head in response to a question, or using body language to demonstrate concern or opposition to something that we're discussing. These observations we want to make part of the record, and many times the court is even going to respond with additional observations. So let's keep this in mind as we focus on maintaining the record and protecting it. If it isn't in the record, it just didn't happen. How many times has this occurred when there's been a discussion, it was not commemorated on the record, perhaps a sidebar discussion? It needs to be on the record, and we need to really take this seriously, because we don't know if there's going to be an appeal, and opposing counsel may or may not be willing to stipulate to any aspect of commentary or any arguments or motions that were addressed. So it's important to make sure that the record is full and it's complete. So the impact of COVID-19, and as prosecutors, we're all very much aware of how our work, our professional work, has been severely impacted by the pandemic. But we also need to make sure that the impact of COVID-19 is also part of our record. We're going to be looking back at this record time and time again in the event of appeals. So it's important that it's complete and it's accurate. When there's a shutdown, and the response to a shutdown involves perhaps shorter court hours or delays or continuances of pretrial or trial proceedings, we need to make sure that the specific impact becomes part of our record. And we also want to make sure that we are demonstrating, again, on the record, and John suggested a great practice point, we may want to have boilerplate ready to go to deploy along with the specifics of our response to any given motion in a pretrial proceeding. But we want to make sure that we are fully documenting the entirety of the scope of the pandemic in our jurisdiction in the state, and certainly in the United States. And these may have to do with shutdown orders. It could be mask requirements. It may be a vast increase in the rate of dissemination of the virus. Whatever that is, we need to make very clear that that becomes part of the record for possible appellate review. There are also judicial responses to this emergency, and we're all very familiar with the orders tolling the running of the speedy trial, and also various Supreme Court orders even extending speedy trial delays. If the court locally has responded to orders and added to any orders, we also need to make sure that this is on the record. We'll be thankful that we did when an appeal may come about a year or two later, but we're able to look back to the record and to fully argue to the court, to the appellate courts, the scope of the pandemic and how it impacted our ability to advance our cases. And showing our work is an important thing as well. As proactive prosecutors, we are undeniably diligent in our efforts. Many of us, and I know many of you that are with us today, have been working at home, some with childcare responsibilities also, and engaged in telecommuting. And yet the work continues, and that needs to be made part of the record too. How many times have you advanced witness interviews through teleconferencing when it was not possible to have a witness interview in a discrete physical location, even with social distancing? What did you have to do to affect this arrangement? Who did you work with in order to make sure that an advocate was available for a victim who had requested the presence, virtual or physical distance, with the advocate? And the continuation of work of multidisciplinary teams, our contact with law enforcement, requesting follow-up, communicating with the state crime laboratory, trying to determine where they're at with the testing of various items of evidence that we've presented. Whatever it's doing, we need to make sure that we're logging all of our efforts in this regard to really demonstrate due diligence in all of our work. We're going to talk a little now about virtual court proceedings. And I know as John and I address some of these impacts of the pandemic that have caused us to vastly change how we do our work as criminal justice professionals, I know that there are many jurisdictions that are using various virtual proceedings, some in terms of jury selection, some in terms of arraignment, and some in terms of trial and pretrial proceedings. So we're going to turn our attention now to some of the issues that may be incumbent with utilizing this new technology. The defendant has rights, as we all know, the right to confront witnesses against them, the right to have access to and be represented by counsel, and to have meaningful communication with counsel. Also, we have rights of the public. The public has a right to access proceedings that are held in court that are critical to their First Amendment rights. And we certainly have the rights of victims as well. And in terms of virtual hearings, we need to give a lot of thought to how we're going to ensure that the defendant's rights are met, as well as the public right, and certainly the rights of victims. When we talk about the rights of defendants, we need to take a look at the situation where a defendant may require the use of an interpreter. We need to ensure that the interpreter is able to present information translated to the defendant and do this throughout the proceeding, and to do it in a way that is not going to impact the ability of other involved parties to hear and to be able to fully absorb whatever information is being presented. In some jurisdictions, the rights of public access are being met through streaming court proceedings. Sometimes in certain counties, this is being done in another courtroom where members of the public are free to come in, to be socially distanced, to wear masks, and to obey other safety regulations, while proceedings from the trial court itself are being contemporaneously screened in. This is only just one of the ways that public access is being met. And we need to make sure in our work with victims that victims have rights under the Bill of Rights and the Victim Bill of Rights. And it's important that they be notified of proceedings and whatever technology is going to be utilized in ensuring their right to be present. So looking deeper into a defendant's right, we want to remember at all times that as prosecutors, we have the duty and certainly the responsibility to ensure a fair trial for the defendant and to prevent error. And it's interesting, there's case law in some jurisdictions, including mine in Washington State, that prosecutors are actually quasi-judicial officers of the court in that regard. This is one of the highest responsibilities at law, and it certainly is one that all of us as prosecutors are proud to meet. we want to ensure that there is a fair trial. We also want to make sure that we're on top of any potential development of error so that we can prevent that to the best of our ability. So there are some areas of concern that we want to proactively take a look at, and also, again, put it on the record, address it with the court and with opposing counsel. The nature of the proceeding, is it going to be evidentiary or procedural? Because there are legal implications to each of these different resources. What do the local rules in our jurisdictions permit in terms of remote proceedings? Nearly every jurisdiction has addressed this on a state level and most on a local level about the usage of platforms, for example, and remote proceedings, how they're to be conducted, which staff are responsible for them, and how streaming is going to occur if members of the public cannot be present. The security of the platform from third parties is a developing area of concern. We need to ensure that the court is addressing the security, particularly, to use one example, if jury selection is being conducted through Zoom. There may be a warning at the beginning from the court, articulated as well as written, that these proceedings are not to be recorded by anyone and they are not to be disseminated. But whatever form that this is addressed in, we need to be very careful that this part of the record is protected and that we demonstrate our due diligence in bringing this issue to the forefront in our discussion with the court. The defendant's right to be represented by counsel, as all of us know, also involves private conferring with counsel. In some jurisdictions, Zoom is being utilized with a waiting room where at a break, a defendant can privately confer with counsel. Again, if an interpreter is going to be involved, we need to ensure that the interpreter is able to hear and present information to the defendant that is contemporaneous with information that is being presented in open court, either through testimony, through argument, or any comments made by counsel or the court. And when we focus on the involvement of an interpreter, we need to ensure the safety of the interpreter in a socially distant, acceptable way, but still able to do his or her professional work. Victims' rights, as I mentioned earlier, are guaranteed under the victims' rights and legislation following in many of our different jurisdictions. We need to make sure that we're getting the information out to victims about the status of the case, whether it's been charged, any that the victim has a right to be present and how that is going to be. We're going to be discussing what kind of technology is being utilized, safety precautions are.
Hi, everyone. It looks like Patty lost her connection a little bit, which please don't take that as a verdict on Washington State. But one of the other dynamic of virtual proceedings that we need to consider is what Patty was addressing with victims' rights too. Although as prosecutors, as Patty talked about, we have an obligation to consider the defendant's rights and to accommodate those when we're arranging for virtual proceedings. We also want to recognize victim rights, especially any that might be protected under a Bill of Rights in our jurisdiction. Certainly at a minimum, that's going to be making sure that victims have a right to be informed and often a right to be present for proceeding. How's that going to look with the virtual, if the proceeding is being conducted virtually? Is it being conducted in a courtroom? Are we letting the victim know that, hey, this can also be attended virtually? Are there socio or economic barriers that might limit or prevent that victim's access to a proceeding or being able to access a proceeding virtually? A lot of times for many proceedings, a victim, in addition to having the right to be present, is also going to have the right to be heard, especially if we're talking about issues that could could have direct impact on the victim, such as bail bond proceedings, a guilty plea, and or sentencing. So if we're conducting virtual proceedings, we want to make sure we're accommodating some outlet for that victim to provide the court or the magistrate or the judge with that sort of input. The other thing, though, is too, in part of having victim-centered, offender-focused prosecutions, as part of that victim-centered dynamic, we want to make sure that even when proceedings are being conducted virtually, that we can arrange advocacy support for our victims. Maybe that's going to be a system-based advocacy with victim witness personnel from our office, from our prosecutor's office. Maybe that's going to be an outside community advocate support. How are they going to be able to participate or support the victim in a virtual proceeding, and also in a socially distanced and safe way, both for our advocates and for our victim as well? Patty, I see your connection's returned. You okay if I just continue with the next batch and hand it back to you?
I sure am, John. Just one fast aside. Isn't it ironic that when I was talking about Zoom, I lost a connection, but I'm back. So thanks very much for subbing in for me.
Well, that's an interesting point too. If your virtual technology or platform fails, as we just had a planned illustration of, it wasn't planned, I'm joking. But if that does happen, how are you going to accommodate the proceedings? How, and whether the breakdown happens on the court's end, the defense end, or the prosecutor's end, what are some backup? What's your plan B in trying to think of that angle as well? Fortunately, Patty and I had a plan B because we're doing this as a team. And if I drop off, she can pick up, or if she drops off, I can pick up. But can you accommodate that kind of plan B with your court proceedings as well? So that was a wonderful illustration that I would love to say we planned, but didn't. So virtual proceedings, the issues we're asking folks to sort of contemplate in arranging virtual proceedings is consider them from the perspective or through the lens of what are the defendant's rights, how can those be protected, the victim's rights. But the other thing with court proceedings is a right of the public to be present. And really, there's two ways in which the public has a right to be present at proceedings. One is the right of the public to be present, more the right of a public access, is the defendant's rights under a Sixth Amendment, which is there to protect and make sure that the defendant's proceedings, that they're open to the public and that they're not being conducted in star chamber fashion or something of that fashion. But the First Amendment, and specifically through the guarantees of freedom of press, and also guarantees the public an independent right to be able to view proceedings and be present at proceedings. Really, the seminal case about these that we're referring to, or that are usually referenced, and these might be, it's a good place to start, and maybe your jurisdictions have further extended these rights, but we reference some of the Supreme Court jurisprudence, so you can look at that as a floor when you're considering the issue, is going to be Waller versus Georgia. That has to do with the defendant's Sixth Amendment right to a public trial and how it extends to suppression hearings, and Press Enterprise 1 from 1984. And that's about the right of the press or the public to an open hearing. Just for background, in Press Enterprise, both the defense and the prosecution were willing for the court to be excluded. And it was the media that actually litigated for their right to be present in court, which the Supreme Court recognized. The underlying sort of presumption for all these proceedings, though, is that there's a presumption of openness to the process. In other words, we're not having our court proceedings conducted or created with a secret sauce that's just given between maybe the court and the prosecutors and the defense, but there's a presumption of openness. That doesn't mean there's an absolute right of openness that we're going to discuss. And there might be circumstances because of the pandemic where we have to make alterations to this, to the openness that's traditionally been involved. Now, maybe our virtual proceedings on some level are demanding or requiring that maybe our proceedings can't be as open as they would in more normal circumstances. Either they can only be open to the public through virtual mediums or through physical public mediums that maybe aren't as open as they were beforehand due to social distancing requirements and health and public health requirements too. When we're trying to look at proceedings where the public openness might be a little bit more limited than was in pre-pandemic times, there's really two prongs that our Supreme Court's given us. And this is from Press Enterprise 2 from 1986, Press Enterprise versus Superior Court of California, another California case. The ability for that proceeding to be closed to the public is going to be depending on both the experience prong and the logic prong. Now, the experience prong relates to whether the proceeding has traditionally been open to the public, and the logic prong is whether public access to the proceeding positively impacts its function in the light of the public purposes of a public trial. Just for background, with Press Enterprise 2, a nurse was charged with 12 counts of murder for administering lethal doses of heart medication. Her probable cause preliminary hearing was closed to the public, and the press sued for that to be open to the public because it was a case of such public interest. And the Supreme Court ruled that it should have been open to the public. Both the nature of those hearings within California jurisprudence, they never had traditionally been closed to the public, and so there is no basis to make a special exception. So even though there's a general rule for our court proceedings that they should be open, that is not to say that the openness cannot be limited in proper circumstances. And probably the one case that sort of addressed the formula for when proceedings can be limited to the public is going to be Presley versus Georgia. And this was, relatively recently, given the age of the other cases, from 2010, and had to do with access of the public, specifically the defendant's uncle, to view voir dire, the jury selection process. And what the court ruled is that the formulation for when proceedings can be closed to the public, they adopted this four-part formula. The party seeking to close the proceeding has to advance an overriding interest that is likely to be prejudiced. The closure must be no broader than necessary to protect that interest. The trial court must consider reasonable alternatives to closing the proceeding, and the trial court must make findings on the record adequate to support the closure. Now, spoiler warning, in Presley v. Georgia, the Supreme Court held that Georgia did not meet this formula, these four prongs or these four variables, and so the voir dire properly should have been open to the public. But if we apply this four-part formula to maybe the necessity to limit to some degree hearings during COVID, maybe these are some of the arguments we want to be preserving for the record and crafting for the record. Now, we aren't going to be able to close virtual non-trial proceedings. We won't be able to close trials to the public entirely, but for virtual and non-trial proceedings for COVID, it's not all or nothing. But using that Presley four-part test, when we talk about the overriding interest to maybe only conduct a proceeding virtually, we want to be what we've discussed already, make a record of public health risks or concern that maybe we're going to chill witnesses participating due to fear of public health risks absent virtual proceedings or virtual testimony. We want to talk about how maybe conducting these hearings virtually is a way to limit the scope of denying public access, because we want to have these virtual proceedings as a way to accommodate public access. And if permitted in our jurisdiction and filming of proceedings is allowed, offering real-time audio or video openness as a way to limit the scope of the public access limitations caused by virtual proceedings. Show the absence of viable alternatives to virtual proceedings. Maybe we can put on the record the nature of our courtrooms or our system, that there isn't really any way or resources to make them safe to the public, or they aren't big enough or large enough to accommodate that. And the other thing too is when we're asking the court to conduct these virtual proceedings, especially for the kinds of proceedings that haven't typically been virtual, we want to ask the court to make findings on the arguments we've proposed. And maybe one part of good lawyering could be to have proposed findings of facts ready which if the court wishes, they can adopt, and that can be part of the record, justifying the necessity for virtual proceedings that might on some level have limited public access. Maybe or the defense counsel is going to agree with these issues too, and they could be joint proposed proceedings. It depends on the circumstances in our specific case. So we've talked about virtual proceedings and some of the COVID-related issues that can come up to that and some of the dynamics we want to be thinking about. We also want to think about something else that's been commonly coming up during COVID is bail and bond issues, and maybe pretrial release or early release type issues and how that's occurring during COVID, during the tensions between both public safety and also trying to minimize risks to public health with the jail systems that might not be able to accommodate pandemic concerns. So, but as prosecutors, while we want to recognize the public health concern, we also want to balance that with the public safety concern. So if there's an argument that we're confronting or an issue we're confronting for release, early release, or a lower security or bail or bond based on a health risk to offender, part of making that record is rather than just a general statement, we want a lower bond or we want an early risk or early release because of a health risk, we want to make sure on some level that that health risk, it's quantified on the record, that it's not just assumed per se. And so what that could mean, depending on the nature of the pandemic in our community, we want to be sure that whether there's evidence of greater COVID-19 risk in our local jail or prison than in the local community. There may very well be, sometimes there might not be. We also want to view that safety risk to the offender, or that public health risk to the offender, in the context of where they're going if they're going to be released. Are they going to be at a home or are they going to be in a public? Could the offender's release also increase public health risks, and be looking at that context? And the other thing we want to be doing too, and just putting on the record for whatever decision our courts ultimately make and our judges ultimately make, we also want to make sure that there's a record of what steps our prison or our jail is taking to reduce COVID-19 outbreaks. Maybe even that might involve having a prison official testify at a bail bond hearing and putting on the record what they've done to minimize these health risks. So whatever the health risk that might exist for a detained offender, even if that is quantified, we want to make sure that on some level there's a record, or at least the court considering that or weighing that with an offender's risk of not appearing or fleeing, what the danger to the public and or the victim might be posed by the offender's release, and the risks of witness intimidation or tampering, especially if the nature of the charges involves something like domestic violence or where there's a pre-existing relationship between an offender and the victim that's usually more ripe for witness intimidation to come up. We want to make sure that that's put on the record as well. So even if there is a public health risk, that it's not viewed in a vacuum, that it's also viewed in the context of whatever risks might exist for an offender's early release. And as prosecutors, it's going to be up to argue these issues and show these issues for the record, because they aren't just going to be presumed. If release or reduction does happen, or if it's appropriate, because there is a greater public health risk to an offender in jail that maybe outweigh public safety or victim safety issues, then one of the things we do want to make sure we do is we keep our victim updated on any request to be released, and also any requests by an offender for an early release or reduced bail or bond. If there's changes in a safety plan that might be able to mitigate risk to the victim, we want to make sure we talk to the victim and their support team about what we can do. Maybe get those conditions added to as part of the conditions of an offender's release. And we want to make sure we communicate with prison and corrections officials so that we can be kept up to date about any release plans, as well as outbreaks at facilities. Because the argument we're suggesting here is not that we ignore the public health risks at prisons, but that we diligently examine them and try to understand the exact extent of those public health risks rather than just assume them. Is your connection okay?
So we're going to turn now to I'm
Sorry.
here. Okay. That was just like a welfare check. So we're turning now to continuances. And when we talk about them, it's important to go back to what John discussed earlier when he focused on triage. Anytime a case is going continued, we all know as prosecutors that it should be continued only upon a showing of good cause. We also need to consider the impact it's going to have potentially on our evidence, on the testimony of other witnesses, and certainly whatever impact it may have on a victim who may have waited an appreciable period of time for the case to be advanced. It was further delayed during the pandemic, and now it may foreseeably be delayed again. Continuances can also greatly impact our case, and we're going to turn now to considerations of speedy trial and pre-accusatorial delay. And there you have it. Avoid continuances as much as possible. And we've all heard the adage, justice delayed is justice denied. It applies to offenders. It certainly deeply applies to victims, especially victims that have had to wait, as I mentioned, for a very long period of time. For victims, once that case is reported and once the case is charged, so many victims, when I was prosecuting sexual assault, domestic violence, and related homicides, the families, the surviving members of homicides, the victims of other crimes mentioned that they almost felt like it was an eternity to have this case addressed. So we need to be very much aware of the impact on victims. We know, though, in the context of the pandemic, that many of our courts now do not enjoy the same capacity as earlier to accommodate social distancing. Some courts in certain areas of the country have been able to rearrange, if you will, the internal structuring of the layout of rooms using plexiglass to separate jurors, using plexiglass of the witness stand around where the court is. But all of these changes in some way or another are going to impact the court's capacity. We know that there have been backlogs of cases accrued around our country. There were backlogs in many jurisdictions just due to the high volume of work coming through the courts. And those backlogs have now been exacerbated by other cases. And so what we're looking at for purposes of triage and advancing cases is also the needs of other cases, and whether other cases have evidentiary problems that would be further impacted, whether a victim in one case is not able to maintain engagement with another continuance. We need to take a look at a myriad of different factors impacting our cases. And we know that in terms of our work as trial attorneys, that evidence and witness testimony can also be impacted with the passage of time. And much of this has to do with the psychological impact of delay on victims and witnesses. Particularly during the pandemic, there's considerable fear by victims, among victims and witnesses, about testifying with new technology that's being utilized, or by leaving their home to come to an area where many other people are going to be, fearing that perhaps social distancing and masks are still not going to be able to remove danger. So we need to really be aware of all of these features of impact from the pandemic and try to avoid continuances unless they're absolutely necessary and well-founded in good cause. Sometimes they're unavoidable, though. A witness may be unavailable, and unavailability can actually be because a witness is in a specific vulnerable group and is urgently concerned about coming to a courthouse or even going to a modified setting in a hotel ballroom, for example, or a sports facility. So unavailability can take many different forms, and we need to examine each one of them very carefully. Sometimes, depending on the witness and the importance of the testimony, sometimes there can be a stipulation that can be negotiated. And perhaps a video deposition is something that we can work through with defense counsel with the approval of defendant. We also want to take a look at the law that might be involved. Is unavailability, which is also a term of art, as we know, is it such that hearsay exceptions are triggered? And so what we're doing during this part of our discussion is taking a deeper dive into not only the status of our cases, but the substance of testimony and the availability of witnesses. And proactively, these are all issues that we want to address in advance and will bring to the court's attention at a pretrial or other proceeding that we've requested. And we need to carefully, again, make that record regarding unavailability and be prepared to argue whether or not hearsay exceptions may be triggered. Court congestion. We know that this is nothing entirely new. In many jurisdictions, we had congestion before the pandemic, but now we have greater congestion because the court's capacity has been limited due to the virus. And so one of the considerations for us as prosecutors, and as prosecutors, we're trial attorneys. Courts have become a second home for us. We want to make sure that we're making a record of our due diligence and our readiness to proceed. And that means going down to all of the preparatory work that we did when we were still telecommuting. It means making a record of how we worked diligently on this given case. Again, even going to the point of contacts with the crime laboratory, with witnesses, arranging for necessary meetings, making requests of law enforcement for follow-up, and law enforcement may have been impacted in their ability to do that. We need to also explore alternatives, and that might be whether another judge may be available when one particular judge is not able to respond to this particular pre-assigned case. And in terms of rounding out the record and making sure that it's full and complete for possible later appellate review, we want to make sure that we're documenting the record about the court's backlog with all of the pending criminal cases relative to the available calendar days. And as we do that, if there has been, for example, an upsurge in the transmission rate of the virus within our community, we want to make sure that we're weaving in that information as well. And then we turn to, for a moment, a defense request for continuance. If it is a defense request, we certainly want to balance our professionalism with the impact on the victim and any prejudice to our case. To accommodate, then we can do so, but we need to make very sure that this is not going to harm our case, impact our witnesses, or make it very difficult for victims to maintain their engagement. This is the defense flip to a rush to judgment, and it's called delay in charging, or pre-accusatorial delay, or pre-indictment delay. We can bring a case within the statute of limitations, but this due process motion for dismissal can still be brought by the defense. And where this may be coming from, it could actually come to us from two areas. It can come from current cases that we were unable to advance due to the impact of the pandemic. Perhaps we needed follow-up investigation. Perhaps law enforcement was unable to make contact with a key witness that needed to be interviewed before we made a charging determination. Perhaps there has been impact in the crime laboratory in reviewing and providing reports about certain evidence that's important for us to know. It may come from cold cases, cases that were delayed for many months or years before they came to our attention, and then were delayed further in being advanced due to the impact of the pandemic, So we'll be talking about this claim and this motion now. So we look at a number of different features of this delay in charging or pre-indictment delay. Perhaps an investigation, but then could not, and perhaps illness impacted law enforcement. Perhaps they had a reduced capacity. Whatever this is, we need to be very sure that we're on top of this and we are documenting it so this information can be presented to the court. We know that these cases, United States versus Marion and United States versus
Patty seems to have frozen there. So essentially, the delay in charging, pre-indictment delay, all too often we hear the defense argument that the decision to charge was a rush to judgment. When we weren't able to charge quickly or promptly, of course, the delay in charging pre-indictment delay motion is the flip of that. And during the pandemic may have caused a lot of issues with delay in charging because of lockdowns or reduced law enforcement capacity. However, any successful claim of a delay in prosecution, although a lot of the defense is going to be, why didn't you charge this earlier when you could have charged earlier? But really the threshold test, and something we should always press the defense on, is a successful claim of delay of causing a due process violation must be based on actual prejudice to the defendant. So in other words, if the delay hasn't actually caused any prejudice to the defendant, then the motion shouldn't carry, even if there weren't good reasons for the delay in charging, which isn't to say we should ignore the valid reasons for a delay in charging, but the threshold test is really going to be whether there's actual prejudice to the defendant. And it's up to the defense to argue not just a general prejudice from the delay in charging, but specifically, how were you prejudiced? Not on speculation, not on theory, but how were you actually prejudiced? Because the other thing is too, usually most delays in cases advantage defendants as memories get older and colder. So a lot of more often than not, and you especially see this with a lot of the untested rape kit cases that are being charged, you want to be able to argue against defense efforts to shift the focus to whether the reasons for the delay are valid. Nevertheless, we do want to be prepared to explain the reasons for the delay, but we want to make sure the court's focus is on whether or not the defense suffered actual prejudice.
Okay, thank you so much, John, for filling in for me. One of the things that I'd wanted to mention, and I don't know whether or not you've already reinforced this point, is that its actual prejudice is a very steep burden for the defense. It cannot be conjectural. It can't be, if this witness were still available, we're certain that this witness would have provided this information. It has to be a higher level, if you will, to be sufficient for actual prejudice. So we need to make sure that we're not allowing the defense to use speculation and claim it to be actual prejudice. But these are two very important cases to be familiar with for federal purposes. And we know that our states, the majority of jurisdictions, actually are requiring actual prejudice to be demonstrated before the prosecution has the burden of explaining the reasons. And those reasons generally are going to be investigatory need. They cannot be, and no prosecutor would ever want to base it upon a tactical advantage over the defense. And there's a lot of case law in this area, but first and foremost, we need to hold the defense to that burden of actual prejudice. Now, does that mean that a judge will never require us to present the reasons for delay? No. In many cases that I argued, we would actually be asked, in addition, what are the reasons for the delay, even though actual prejudice had not been established. So it's really good to be prepared for all of that. But there are some other strategies too that can help us meet this claim of delay or pre-indictment delay. In our investigations, we need to make sure that we're asking law enforcement to interview all necessary witnesses. So foreseeably, in a case where this claim is going to be brought, defense may say, well, this witness is no longer available, and the information about my client's whereabouts during this specific timeline could only be provided by this witness. And so this is actual prejudice. We should be able to respond that there are many other witnesses available that we have contacted that could foreseeably provide this information if it was reasonably to be expected as true. So a complete investigation is one of the best means that we have of preparing to proactively meet this claim of pre-accusatorial delay. We want to make sure that we're carefully preserving all of the evidence and the witness statements. And if we're doing follow-up on a cold case that we are determining charges for and proceeding with, if there's follow-up, we want to make sure that that is done and recorded. And we also are providing all of the information from the earlier investigation as well. Is there any delay that was directly caused by the defendant? Was there witness intimidation? Can we establish that the defendant had harassed a victim or a witness and contributed then to their unavailability? We need to really take a serious look at any missing or absent witness to determine what the context is, and if the defendant were involved, or if not, what other reasons may have been operative. A victim who is sexually assaulted may have been threatened either directly or indirectly and was extremely fearful of what would happen when charges were brought, and may have changed locations or residences, or may even have moved. And this may have contributed to a delay as well. And that relates directly back to the conduct of the defendant. If there's impact to our case as prosecutors, we need to bring that forward as well. If there had been an ability to bring this case earlier, then other witnesses could have been available to the state as well. So presenting all of this information to the court is important. And again, we do it in the context also of the pandemic and this additional layer of trauma for victims, as well as other witnesses who may be seriously concerned about their health in responding to the needs of the criminal justice system.
So the next issue that we anticipate may come up in the forum of either habeas corpus issues or post-conviction collateral reviews are going to be negotiated pleas, and the utilization of negotiated pleas on some level, maybe to alleviate some of the backlog and case backlog that has been caused by reduced court availability created by the pandemic. Now, specifically, what we sort of anticipate being a possible issue or growing here is the possibility of after the fact allegations that COVID-19 backlogs leveraged a negotiated plea. In other words, a defendant's or offender's later claim that the only reason I took this plea or I accepted this negotiated plea is because the court backlog caused by the pandemic had suggested that it was going to be so long until I get my day in court that I really didn't have any option besides this negotiated plea that the prosecution had agreed to. So one of the things that we want to do is, in order to respond or rebut the potential claims, is something we always do when we're taking negotiated pleas and making a complete record, is we're trying to make a complete record and establish the voluntariness of the offender in accepting the plea and entering the plea and in pleading guilty. But part of the thing we want to do too is we don't want to show that this negotiated plea, that it was just one-sided on the part of the prosecution and the defense. So in negotiating a plea, and when this plea is entered, we want to make sure that the record is clear that in negotiating the plea, the prosecution also waived or gave up the opportunity to pursue other charges or a potentially higher sentence, and make sure that that's on the record to be a plea. Because of course, what we're trying to create a foundation for down the road is that a defendant's tactical decision to plead in a case does not equal coercion and doesn't vitiate or take away the voluntariness of the plea. Other thing, and this is something we need to do anyway, even when we're negotiating pleas in the absence of a backlog, we want to make sure all terms and conditions of the plea agreement are on the record. Even if they're in a written document, we want to make sure that that document is understood and adopted by the defender. That if there's no contact or other conditions as part of a plea, we want that to be detailed and put in the record and make sure it's accepted by our offender, as well as all penal consequences, including the range of penal consequences or possible sentences that are being avoided due to a plea, as well as being exposed because of the plea. Part of negotiated pleas, though, we want to be, as always, discussing our potential plea offers with the victim, and we want to be open with them about the trade-offs involved with the plea. And this is just we don't want to necessarily, while we may make a recommendation, we want to be making sure our victims can give us informed input. In the context of the pandemic and COVID, one of those trade-offs might be, hey, this negotiated plea, it gives a possibility of a quicker resolution to a case than maybe a backlog court calendar can provide. But maybe what our conception of a backlog court calendar or delayed resolution might not be the same as a victim. So we want to even try to be as specific as we possibly can, talk to them about specific potential timelines for resolving a case with a plea and with a trial. Potential exposure, what could happen to the offender with the trial conviction as opposed to a plea, versus consequences and evaluations of having a bird in hand versus six in the bush and other like considerations. But we also want to remember that despite this backlog with cases and the temptation just to move things off in fire sales off our docket, the COVID-19, it doesn't resolve us as prosecutors of our responsibility to pursue resolutions that seek justice not just for our victims, but also for our community and for considerations of public safety. And the COVID-19 pandemic has not absolved or delayed that responsibility, but that is ever present. Relating to sort of issue with waivers too, is there might be a lot more willingness or openness to pursuing bench trials, waiver trials, whatever they might be referenced to in your jurisdiction, as opposed to jury trials. And again, sort of the appellate or post-conviction collateral litigation issue we're anticipating here is defense potentially arguing that jury trial waivers were only done because of COVID-19 almost made a Hobson's choice of a prolonged delay for a jury trial, and so that there was no meaningful choice. But same thing we're doing with the negotiated pleas. We want to make sure that in a defendant's waiver of the jury trial is clearly and expressly stated on the record. And if there is a clear and knowing involuntary waiver, we want to point out that rights can often be exchanged for perceived benefits, such as guilty pleas, such as waiving readings of charges, everything, and make sure that that's pointed out on the record. Also, we want to be alert to pointing out the timing of any objections to a bench trial. In other words, the obvious argument is that after a judge has already rendered a verdict of guilty, it makes the sincerity of the objection to the waiver of a bench trial seem a little less than genuine. And we also want to note too, and be careful to observe that certainly if our judge gave a split verdict at a bench trial, highlight that as evidence of the judge's impartiality. But there's also, we want to talk about too, some general pretrial practice tips, both during the normal and the new normal created by the pandemic. One of the things we always want to be doing is as much as possible. And for folks who usually are only doing courtroom practice, maybe have it rely on a separate appellate department, And as much as possible, you want to try to be filing written motions prior to trial or prior to proceedings. These motions are helpful in multiple ways. One, they help you identify issues in the case, but they're also going to be good vehicles to help inform your trial judge or your trial court about the issues involved and give your judge a better chance to make the record. But again, filed motions, the other thing they're going to be doing, because it's something Patty and I are constantly going back to and referring to, is they are also going to be good vehicles to inform the court and supplement the record. We want to be sure that we can document the specific. Sorry, I thought we were having some technical problems during the proceeding. We want to be sure that the motions we're filing, they can document the specific impact of COVID-19, maybe stating or listing the boilerplate issues involved. These motions can also demonstrate and illustrate our due diligence by proactively addressing issues relating to social distancing, virtual presentation. In other words, by filing these motions, we're supplementing the written record. If our judge is just going to make a conclusory decision, oftentimes on appeal, we can say, hey, the judge is often going to have language he considered motions filed by the parties, and that can become incorporated as part of a written record and relied on as the basis for the trial court's decision or exercise of discretion. So sorry, folks, we had some technical disruptions here that sort of distracted me during the presentation. So sorry for any disruption in the flow there. Patty, you okay if I hand off to you?
I sure am. Thank you so much, John. So let's turn to defense motions now. It's really good to have them filed. It doesn't leave us to guesswork or trying to foresee what their strategy might be. So it's great when they're filed. Filing a written response is good trial practice for all of us. Although sometimes we're left with a very short time to do this, if we prepare with boilerplate, again, making sure that the impact of the pandemic is featured, if it's appropriate to this motion, then it's basically a matter of providing additional information that's relevant to the motion. If there is something that we should agree to, then we should. We're not trying to actually litigate everything when it's unnecessary. And it also demonstrates to the court the integrity of our work. But we don't necessarily concede just to be of assistance on a detail. If this one issue could lead to greater challenges, we need to analyze this very holistically before we agree to a stipulation. Developing insight into defense strategy is important, and John and I have been discussing with you through this presentation some of the insight that we've developed with the help of many other prosecutors around the country in trying to proactively meet the issues that are either coming up now or can reasonably be foreseen. In doing this, if we anticipate for example, with pre-accusatory or pre-indictment delay, that even if the court denies that motion to dismiss, we need to know that the defense can still weave in some of this information through witnesses that are called at trial. So this is a really great example of where we need to address proactively through a motion in limine what we expect will happen when the motion for pre-indictment delay is dismissed, or any other motion for that matter. When it comes to evidence, we can never have too much. And what's really important to us in terms of our work as prosecutors, we are going to provide evidence to corroborate not only the victim's disclosure and the core of the case, but all other necessary details which form the context of the crime. We know that it increases the security of our case as well as the possibility or probability of conviction. Also, developing this kind of an outlook about evidence can really minimize potential trial errors. If we have multiple witnesses who can testify to different aspects of the crime or the context of the crime, having these witnesses testify in a non-cumulative way is certainly going to provide a stronger case for the jury's consideration, as well as a firmer case for purposes of resisting error on appeal. So preparing is the first step to making sure that we have a favorable record. And that means looking at every aspect of our case, determining witnesses and evidence supporting the disclosure and the elements of the crime, but again, also the context of the crime. How many times have we been in a trial where the defense even seemed to fluctuate as the trial commenced and as witnesses testify? With this kind of preparation, we're going to be in a great position to meet that defense, however that defense develops in a trial. And we always want to, in terms of our work in preparation, determine how we're going to lay an appropriate foundation when foundation is necessary. And when laying a foundation, we have certainly legal requirements, but in addition to that, we have a jury that's present. And so we want to make foundation also, in addition, persuasive to the jury so that they're going to understand also the importance of the evidence that we're presenting. Why is this important? If anyone has ever experienced a reversal, it becomes a challenge, certainly a challenge that we can still meet, but it is a challenge to retry that case. We have a record, we have witnesses who have testified. We know that any nuance or deviation from prior testimony is going to lead to certain issues. Sometimes evidence may not be available that was previously available. Sometimes witnesses have been through numerous proceedings and they may be unable to stay the course. But we also know that as prosecutors, even if we are challenged in trying a case again on appeal, this is certainly a responsibility that we can meet, going back to everything that we've discussed today and making sure that that record is firm and is replete with all of the information that's necessary. If there has been harassment or intimidation of a witness who has previously testified, then that certainly is information that may obviate why a memory faded or why cooperation is still not intact. So we need to be very much aware of a holistic view of our cases that are coming back from appeal. So we also know that in terms of the backlog, and I think we've discussed that in some detail today, and the bottleneck that's formed in many jurisdictions, it was present before the pandemic. Now it's been greatly exacerbated. A reversal is going to challenge these resources even more. It is very injurious to victims who have waited for their case to be heard. It can disrupt the healing process for them, and it certainly can contribute to the trauma that they've suffered. So we want to make sure that we're presenting the best cases, the strongest ones, that we're anticipating any possible development of the defense during the trial, and that we're presenting all of our work very carefully in a legally acceptable fashion to the court and to the jury. That goes without saying, doesn't it? It's not a lot of fun for us, but we also can certainly meet this challenge and even many more. Going forward, what we've talked about today, we want to make sure that we're all proactively looking at these legal issues that we've had the opportunity to describe for you, as well as others that you're seeing in your jurisdiction that are coming about from the impact of the pandemic, and specifically from delays that have occurred due to the pandemic. If you need any support in this area, John and I have been assisting various jurisdictions with answering motions to dismiss based upon pre-accusatory or pre-indictment delay. Responding to motions in the context of the pandemic, it's critical that we provide a full resource of all of the court's prior orders that were occasioned by the pandemic, as well as the local impact. We can even foresee a potential issue, a speedy trial issue, coming when the defense is talking about how other jurisdictions surrounding one jurisdiction may have opened the courts earlier and did not have the degree of delay as in a specific jurisdiction. So we want to make sure that we're fully addressing the impact specifically on your community, jurisdiction, and state, and being aware of the rate of transmission of the virus and the kind of accommodations that this has required. And finally, establishing a detailed record of the impact and the due diligence that we take as prosecutors is critical. Every prosecutor participating in this seminar today, and every prosecutor who may listen to it, we know how hard you've been working. The court needs to know it too. They need to know the detail of all of the due diligence that you've brought to all of your work to advance justice for your communities and for victims. This is my business card. You'll be seeing John's in just a second. I would be honored, as would John and my other colleagues, to respond to any questions that you have. If you need technical assistance in the form of consulting with us, we would be honored to support your efforts. I want to thank you so much for the opportunity of being with you today and discussing these areas that are so important to prosecutors during the pandemic.
And I'm just going to sound off after Patty to thank everyone for your participation in this webinar, whether you're listening to it live or whether you're listening to it as a recording. My apologies for any sort of technical hiccups. That sort of illustrates, I think helps illustrate though, what the things we have to adapt to and be prepared for as prosecutors. And thank you all for not only attending today's webinar, but for the work you do, especially in these unusual and trying times. Now, we are done a little bit early, and so Patty and I can hang around. I didn't see any questions that came up in the chat window or the Q&A window, and I don't know if you have access to your microphones, but if there are any questions or maybe issues or angles we didn't address, we'd be happy to discuss it in the time remaining. Otherwise, we can wind up, but we'll hang out, and Patty and I can be sure to be the last ones to leave if you want to sort of keep your questions saved. And I see the attendance list slowly decreasing, but there's some other people still here.
Thank you.
I see 13 people are left, Patty. Oh, for the 11 attendees that are still here, if you ever want to go back and view the recording, you go to our website, equitasresource.org, click on the resource tab. It should be available there with, I don't want to rush it, but I anticipate probably within the coming week. Patty, I don't see any questions coming up. I think we can sign off.
Okay. For anyone who still is there and listening, thank you so much for being with us today. Please don't hesitate to contact us at Equitas.
Thank you, everybody. Bye-bye.
Bye.